holiday we all agree on and can enjoy and have fun. Okay, so it's Monday, March 17th. Glad to see everybody. On the agenda today, we're going to go ahead and work one thing, and then we're going to hear one House bill and one Senate bill. And then we're going to try to knock out 5 to 7 bills with working them. And what we don't get done, we will do tomorrow. And we do plan on meeting tomorrow. We have no hearings. We'll probably work the 2 bills that we are hearing today and whatever bills that we don't get finished with. So that's kind of what the plan is. So, okay. So first of all, we're going to go ahead and work SCR 1611, which was the constitutional amendment that we heard on Thursday. Jason, you want to give us an overview of that?
Thank you, Madam Chair. Good afternoon, committee. Jason Thompson, Revisor's Office. So this is the constitutional amendment that would provide for direct election of Kansas Supreme Court justices and do away with the Supreme Court Nominating Commission. I think I'll leave it at that.
Okay, great. Committee, what comments do you have? Do we have, go ahead, Representative Osmond.
Thank you, Madam Chair. If you'd like a comment, the comment is no. I'll elaborate further later.
Okay. Any other comments? Representative Lewis.
Yeah, so I'll start the discussion after my phone stops ringing.
Ooh, the last day we get treats.
We're about finished. I don't know if I have time. We'd only have one more day.
Yeah. Go ahead, Representative. Yep.
More seriously, the SCR 1611 really comes down to one issue. Do you trust the voters of Kansas to select the 7 people who run the third branch of our government and who have an enormous impact on how our government's run and on your daily lives, both business and personal? I do, and I therefore support SCR 1611. Let me explain. One of the chief reasons I ran for office was my concern that we, the people, over the last 100+ years, have been ceding way too much of power over our lives to unelected and unaccountable elites. The seeds for this started in the late 19th century when Woodrow Wilson, then an obscure political science PhD student and later professor, wrote several tracts which focused on what he considered a radical defect in our constitutional structure. And what he really meant by that was we had people were too involved, elected officials were too involved, politics was too messy, and the solution was to clean everything up and to cede all our power to an elite, a professional administration. It was pretty, I mean, he was unabashed about that. Now the seeds were planted in late 19th century, and they really sprouted in the 1930s with the New Deal. That's when an alphabet soup of administrative agencies were created, from the FCC to the SEC, to the FDIC, to the NLRB. And these were all run by unelected professionals who didn't have to and never have to answer to the voters. So how does that have any impact on the issue before us today? Well, our judges, our justices in this case, in this state, were indeed, for the first 98 years of our state's existence, elected. But in 1958, there was a political scandal that arose, not because of anything having to do with the election of justices, but simply because under that system, it had to do with how justices that retired early were selected, and therefore you had the infamous triple play, which I think most people in the room probably know about, where a Republican governor was a lame duck. He wanted to be Chief Justice of the Supreme Court. Chief Justice of the Supreme Court was his friend. He worked it out where the Chief Justice resigned. The governor then resigned one day. Next day, the Lieutenant Governor then appointed the governor as the Chief Justice. And there was political outcry, as there should have been. But then what happened is they threw the baby out with the bathwater. They threw out elections along with the process by which you replace early retiring justices. And this is all in line with the movement at that time, as I said, to take power away from the people and hand it into unelected elites. And in this case, the elites turned out to be a professional group known as lawyers. And the process now, as we know, has to do, the lawyers control it. They have 5 of the 9 nomination committee members. The chair is also a lawyer. And it just so happens that Friday night when I got home, I received a letter from the Supreme Court of Kansas. And it said, Notice of Election, Supreme Court Nominating Commission Chair. That's the heading. Between May 1 and May 15, 2025, an election will be held for the chair position of the Supreme Court Nominating Commission for a 4-year term. Those lawyers who are residents of the state of Kansas, licensed to practice law in Kansas, and are in compliance with KSA 2107. Goes on. Only lawyers who were on the certified roster as provided by the Office of Kansas Attorney Registration as of February 15, 2025, and provided to the Kansas Secretary of State are eligible to nominate or vote in the election. So, look around this room. I believe there are, I'm guessing there are three of our committee members that are eligible to vote for the chair of this nominating commission, and there are probably a handful in the audience. When I went to town hall on Saturday, there were probably 70 or 80 people in the room, all engaged citizens who obviously were interested enough to show up on a Saturday morning to listen to politicians talk. And in that group of about 70, I counted 4 lawyers. That's not fair. That's not right. This is too important to leave it to a handful of elite professionals to decide. Quite frankly, it's beyond, in my view, it's beyond the pale. In a society, in a country that prides itself on giving the right to govern our lives to the voters. So there's other problems with the nominating process, with lawyers being in charge. First of all, there's a conflict of interest. I suspect that most, if not all, no, most, I won't say all, but many of the lawyers that are selected by their peers to be on the nominating committee are going to have business before the Supreme Court of Kansas. And I don't think it's healthy for them to have such an outsized control over who those justices are. Also, I don't think that this group of people, of which I'm a member, or probably, I think polls would show they don't share the same values as Kansans at large. I don't think that's a good idea. So the question really is, should the voters or lawyers select justices? I vote for the voters.
Would you like to make a motion?
Yes, I move that.
It's up to you. I mean, just.
Excuse me? Yeah, I'll make the motion. I move that we pass SCR 1611 out favorably.
We have a second? Representative Barrett seconds. Okay, what other discussion do we have, committee? Representative Osman.
Thank you very much, Madam Chair. So with regards to SCR 1611, I think the 2 questions that we need to ask are, is the status quo bad or ineffective? And is the modified proposal better? And my argument would be that the status quo is neither bad nor ineffective, and that the proposal is not as good as the status quo. The argument that was made by the proponents, one of the arguments is that what we have right now is a terrible system. It it is not a terrible system. It's adopted by at least half of the states. It's been in existence for the last 75 years, and it came into existence because of problems with what was the status quo to adopt this this layout where you actually have a nominating committee. Now, the proponents also brought forth information that said that the Supreme Court of the state of Kansas is ineffective. They've been overruled 87.5% of the time. Hopefully, you all got legislative research to show, number one, that is completely false. That the vast majority of all Supreme Court cases that state Supreme Court cases that make it to the Supreme Court are either overruled or have their information or have their judgments vacated and remanded back down to the courts. The reason why is because Supreme Courts get the option to select what cases they want to hear, and they want to hear those cases that they have questions about. And when you look at it across all states, Kansas is not an outlier. In fact, it appears as if, based on the statistics, they're doing quite well in terms of their judgment, whether it's cases that have been overruled or cases that have not even been heard because the case itself is one that that the Supreme Court doesn't want to hear, which is the vast majority of the time. Kansas Supreme Court seems to get it right a considerable amount of time. But we look at whether the modification that's suggested under HCR or SCR 1611 is better. And again, I would argue no. Judges are not politicians. They shouldn't be put into the position of being a politician. You have the Supreme Court of Wisconsin is one that they do have to campaign, and they campaign at a $50 million price tag for a court position that, again, we're not even just talking about district court or appellate court. We're talking about the Supreme Court, where they are dealing with extremely complex pieces of legislation and extremely complex nuances of the law that they're trying to determine whether a court of appeals or a lower court has gotten it right. And it takes a specialized person, a specialized mind to actually come to that decision. I could run for the Supreme Court. I don't think I'm remotely qualified. And I'm just putting that out there, that I don't think that a good number of the people are remotely qualified to be a Supreme Court justice. So if this were to go ahead, I'm certainly not putting my name in the hat for it. But sorry. The other part of it is the question of what is it that they're going to be campaigning on? Because understand that you're not looking now at a nominating committee that would, as they proposed, would spend weeks and weeks delving into everything that they've read, everything that they've written, every opinion that they've had, people that they've worked with, into that hardcore background research to make a determination. The voters aren't going to do that. And I want you to imagine, we're all politicians here. Imagine that we had to campaign not on every social issue, but about the complexities of what goes on in Judiciary as a committee. Could you imagine trying to explain to voters as the only thing that you campaigned on things like, I'm very good about the rules against perpetuities, or I can deal with restrictive covenants, trying to explain these nuances to voters. Voters are smart and capable, but there's a reason that we don't leave these particular decisions to the voters, and it's because this shouldn't be a political position. This should be a position based upon skill. your skill set and your ability to do the job. And I think that that is best left to experts for this particular situation. So I'm not in favor of SCR 1611. Thank you very much.
Representative Vaughn.
Thank you, Madam Chair. And I agree with everything the former representative just said. I wanted to speak specifically to some of the comments that were made earlier. And in particular, I would argue that right now, these justices are accountable to the public, in my opinion. We have the retention vote. And I think that is what strikes the right balance in the current system. You know, no system is perfect, but I do believe that there is an opportunity with the retention election that if a group of concerned citizens strongly disagrees with, you know, the rulings or the outcomes of a particular justice, that they currently have the capability with after a year to run a campaign to ensure that, you know, to run an educational campaign to ensure that that justice is not retained on the bench. So there is a check and a balance currently in place that I believe maintains public accountability and voter accountability in that way. And I would also argue that the judiciary has never been intended to be a co-equal political branch of the government. It is a co-equal impartial branch of the government that provides an important check and balance on the other two branches. And the current process that we have, the merit-based selection process, ensures that those justices are chosen based on their legal experience, their judicial temperament, and their qualifications rather than their political allegiance. And I think that that is really important to maintain. If we pass this judicial election SCR, I think what that instead does is open up our Supreme Court to an unprecedented amount of dark money and special interests, and inviting them into the process of justice in our state. I think we all know as politicians that the best funded candidate tends to win. I think we all know, you know, whoever runs the better, whoever has the more well-funded campaign, I think tends to come out victorious. And I don't necessarily think that, I don't think that that is what should determine the outcome of these elections. These justices should be chosen based on their expertise and their qualifications. And not to mention all of the conflicts of interest that this brings to mind. You know, if we have these outside groups who are funding these candidates, what happens when those individuals or those groups come before the Supreme Court in a case or show up? Show up in a case. I think the conflict of interest there is potentially significant, and I have issues about or concerns about that as well. So you know, as we've heard, no system is perfect, but I think our current system strikes the right balance between choosing these justices according to merit with a nomination committee that is a balance of both attorneys and non-attorneys, and that also provides for the retention elections, which gives the voters a voice in whether or not those justices should be retained. So I think our current system strikes the right balance. I think opening up the system to partisan elections poses significant risks for the for justice for people in Kansas. And so I'm strongly against this SCR, and I think that our current system works. I also think that that's proven nationally, because every single state that has chosen to switch to a merit-based system has never gone back. And I think that there's a reason for that. And I think that we as well should stick with the merit-based judicial selection process.
Committee, any other comments on Representative Barrett?
Thank you, Madam Chair, and I definitely appreciate the comments of those already. I would just say, you know, I have a perspective of someone who works for an elected official that's in part of the judicial side, right? A district attorney. And that's something we have to remember is all of our county and district attorneys who hold the the role of someone's life, their future, whether we charge this person with homicide, whether this person it's a self-defense claim. They have 100% of that power. They are the chief law enforcement officer of that county or that district, and they're elected. We trust Kansans to pick the best candidate. And 21 or 22 other states have voting. When I look at it, similar to Representative Lewis, I just feel that people should have the power to elect these officials. And so that's why I'm voting in favor of it. Thank you.
Representative Lewis. Representative Esau.
Thank you, Madam Chair. As I've been listening to all of this, what comes to my mind is the number one question I've heard over the last 30 years from friends and even people at the door is, how do I evaluate the judges and how do I know which ones to vote yes to retain and no to not retain? And most of the time, I can't give them hardly any information at all. I usually default to, if you don't know, vote no. Obviously, that doesn't work because they all get a yes vote, more than 50%. So changing how we do it to give the people a chance to hear from the judges, because right now they can't go out there and tell you where they stand on their core beliefs about the Constitution and how they evaluate cases. It's not a philosophical thing for me in the sense of conservative versus liberal, Republican versus Democrat, or somewhere in between or on the extremes, but more about this is how I look at cases. And I think opening it up so that the people have a choice after hearing where judges stand on those things is a good thing. And they want to know, the people really want to know, how do I evaluate judges? So I'm hoping that by opening it up for elections, that it gives them more information, which is why I'm comfortable voting for this, so that the people have a choice.
Representative Lewis.
Just following on what Representative Esau said, having to do with the voters and whether we trust them to make this important choice. At my town hall the other day, one of the opponents of this process talked about how he was a judge and had gone through the nomination process and had been interviewed by the committee. And he said, you know, the lay people on that committee were asking very probing, appropriate questions. And my point is, yeah, and that's why we should trust the lay people of the state to do that very same thing in a competitive election. The reason the retention elections don't work is there's no competition. Here we would have competition, we would have an exchange of ideas, the people would have a choice as between this or that. And they, quite frankly, the retention system is toothless. I think one of our conferees said in the last, many years in Kansas, one just judge, and it wasn't a justice, was not retained. And then this idea that somehow we're going to, this quote, so-called merit system is a merit system, and the idea is somehow that it's removed politics from the process is, I think, smoke and mirrors. I mean, there's politics in this system now. The problem is it's not transparent. And we need to bring transparency to the process so that more people can get engaged and more people can have a say in who runs our third branch of government.
Any other discussion, committee? Representative Schreiber.
Thank you, Madam Chair. Friday afternoon, I was driving home and somebody texted me from down in Emporia and wondered what this text was about that they had received. And so I looked at it. I wasn't driving, but I looked at it, and it was a meme with me with puppet strings and saying I was being manipulated by the trial attorneys here in the state, and to call and say, ask me to vote for SCR 1611. What came after that was I had a lot of text from people I know in Emporia, my constituents, far and wide, saying, no, don't vote for it. But I think it's an example, even before a committee vote, for something like this to come out, the type of electioneering that will occur when the Supreme Court justices are up for election. We've all seen it. I mean, in our own elections, postcards with strange pictures and sayings about what we've done or not done, which is just par for the course. But I think with selecting the Supreme Court justices, I think that kind of material will influence the vote to the point where it's not the best system compared to what we have now. There's people always ask me at every election, when they get these postcards and texts and so forth, why do they do this? They're just obnoxious. And I tell them, because they work. They don't do it because, they're trying to keep the printers in business. They're effective. And I think that kind of electioneering, coupled with the selection of the Supreme Court justices, is not the best option. So I'm opposed to 1611 for that reason. I mean, the meme didn't bother me. It did put me in a light gray suit, and I don't even own a light gray suit. But so it doesn't really, I don't take them personally anymore after a few years. But anyway, that's why I'd be opposing. Thank you.
Thank you. And I will publicly say I saw it, and it might not have bothered you, but it bothered me. Any other discussion? Representative Osmond.
Thank you, Madam Chair. So Representative Esau said that some people come to her and ask, how do I find out more about the judges that are out there? They ask me as well. So I'll tell you, there are resources out there. I just looked up because I had somebody that contacted me in my last election, and I said, first you can go to the Kansas Bar Association and gave them a link there. They've got recommendations as far as judges go. You can go to Ballotpedia. That gives you a lot of background information about judges. You can go to individual articles that are written. And then last but not least, if you wanted to, you can find out who's specifically endorsed those judges and make your own determinations as to whether you support or don't support those individual things. But there's a lot of background research that one can point to say, is this a qualified judge or not, to help you to make the decision when you go to the ballot box.
Okay, committee, any other comments? Representative Carmichael?
Thank you, Madam Chair. I'd been very tempted to sit here and just listen because I think my colleagues are doing a good job of expressing the merits of this legislation both ways. I would remind people, though, that the sources of information for Supreme Court justices are much more broad than just looking at the lawyer's website. Every year, I make it a point, the Sunday before the election, to drive by a church or two in my neighborhood and make sure and pick up, for example, Kansans for Life's endorsement list. It's not like people don't know. The reason we don't throw out judges and justices is because they are among the best and the brightest. Overall, they do a good job. And the majority of Kansas voters in election after election after election vote to retain the judges who were originally nominated and selected through the merit system. If the merit system did not work, then we would see judges being routinely thrown out in the elections which occur within 2 years of their initial qualification and appointment. It does not happen, and it does not happen for good reason. Now, were it necessary to change our selection method, I would suggest to you that of the 3 major options, the merit system, popular or partisan election, and appointment by the chief executive and confirmation by the Senate, which, by the way, is the method that the United States has used since the founding of the Republic. But of the 3 alternatives, popular election is by far the least desirable. Turn only to our neighbors in Oklahoma. I believe it was about 1964. There's an excellent book written by a former justice of the Oklahoma Supreme Court called Justice for Sale, and it describes exactly what happens in a partisan election system. Businesses, let me back up a minute. This isn't just about the situation involving criminal prosecution that my friend Representative Barrett speaks about. The majority of the cases that are coming through the courts and where the real influence lies is the civil cases, not the criminal cases. And what happened in Oklahoma was the situation with business running the court, selecting the justices, and then telling them what to do in a partisan selection system got so bad that literally bag men from businesses with matters before the court were delivering sacks of cash to the justices in their chambers. Now, I have grown up as a lawyer for 42 years in a partisan election district in Wichita. You may recall that I mentioned some during the hearing that back in the early 70s, I'd even written a letter to the editor suggesting that partisan selection was the way that we should go when the decision was made whether Sedgwick County would be a merit selection or a popular political election county. And clearly I've changed my mind. I have seen with my own eyes in that political system circumstances where the outcome of cases could be predicted in advance based upon the party of the judge and who had campaigned for and contributed to the judge. Now, some people may say, oh, you're insulting the current judges. I'm not. I'm not referencing events that may have happened in Sedgwick County more recently, and I'm deliberately avoiding those. But I can tell you when I was a young lawyer, I was sent up in a civil case by my boss to argue a motion in a case where I told him, boss, there is no chance that we're going to win. We don't have this on the merits. We need to withdraw this motion. This is an embarrassment. We're going to lose. We're going to hurt our good name and our reputation. And my old boss just smiled and basically said, it's all taken care of, young man. Go up there and argue that motion. And I went up there and argued that motion, and not because of my legal skill or acumen, but because the political fix was in, justice was not done. I urge my colleagues to think very carefully about what you're about to do. Thank you.
Committee, do you have any other comments? Okay, seeing none, we're going to go ahead and vote. Representative Lewis,
As I close and move my motion.
thank you. Okay, committee, you have a motion in front of you to pass SCR 1611 favorably for passage. All those in favor say aye. Aye. All those opposed, no. No. The ayes appear to have it. The ayes do have it. Absolutely. All those in favor, raise your right hand. All those opposed, raise your right hand. The motion passes 9-7. And we have passed SCR 1611 favorably for passage.
Madam Chair, would you please record my no vote in the minutes of this meeting?
Yes, and Representative Vaughn also. Representative Martinez also. Okay, thank you. Yep, we will do that. Okay, thank you, audience, for being patient with us since we needed to go ahead and work on that. We will now go ahead, I'll open the hearing on House Bill 2404 and ask our advisor, Jason Thompson, to give us a bill brief on that. Bless you.
All right, thank you again, Madam Chair. As you mentioned, Jason Thompson, Revisor's Office. House Bill 2404 is a bill that prohibits certain sex offenders from entering onto school property or attending school activities and provides criminal penalties for violations. You can see new Section 1 would be a section of law that makes it unlawful for a sex offender who is 18 years of age or older and whose underlying crime for which they are required to register was a crime against a victim who was less than 18. It would be unlawful for that kind of offender to enter onto school property or attend a school activity. Those are both defined in a later section, so I'll mention that in a moment. The penalty for violation you see there is the same as a violation of the Offender Registration Act under KSA 22-4903. That's a severity level 6 first-time offense, 5 for a second-time offense, and a severity level 3 for a third or subsequent conviction. Section 2 just amends the citation of the Kansas Offender Registration Act to include Section 1, so that's all that's doing. And then Section 3 amends the definition section for the Offender Registration Act, and that's where you'll find the definitions of school activity and school property that I referenced a moment ago. You can find those, and I won't read them to you for the interest of time here. You can find them on the bottom of page 6 onto the top of page 7. And just broadly speaking, it's public schools and accredited non-public schools. And the public schools includes both K-12 and like the pre-K programs for those students. It would take effect on July 1st if adopted, and I'll be happy to answer questions if I can.
Okay, committee, what questions do you have for our revisor? Representative Vaughn.
Thank you, Madam Chair. Thank you, Jason. I'm reading through the definitions right now, but I was wondering for like school activity, for example, does this also include events in which other students will not be present? The scenario I'm thinking of is if this is a parent, for example, would they be able to attend like a parent-teacher conference, or would this exclude all on-site activity at a school?
Madam Chair and Representative, so that would, if you had to go on school property, no, you're not allowed to go on school property if you fall under the definition of offender, the special definition of offender that we talked about. There are no exceptions carved out for it at this time.
Thank you.
Any other questions for the committee? Jason, I do have, oh, did I see a hand? Yes, Representative Martinez.
Thank you, Madam Chair. And this would include graduation?
Madam Chair, any school activity or any school property.
Off grounds? It's off school property, graduation?
That would fall, Madam Chair, I think that would fall under the definition of school activity because that's the activity sponsored by the Unified School District at which students in grades 1 through 12 would be in attendance. So I think it qualifies and you would not be allowed to go.
Thank you.
Jason, I do have one question about, in general, our Kansas Offender Registration Act. Is this the first thing in our Offender Registration Act that says an offender cannot do something? I know there are many things they must do. They have to register 4 times a year and it's this much, and every time they move or sell a car or whatever. Are there any other things that they cannot do?
So, Madam Chair, it's a good question. Nothing in the statutes that I'm familiar with is a restriction on what they can do. It's, like you said, it's more you're required to register a certain number of times and pay a fee and update when you move, et cetera. But there aren't any restrictions such as this or restrictions on where you live or anything like that. Most of those are done by separate entities. It's not in a statute.
Yeah, because we did hear from someone on the offender registration list that can't coaches children or different things like that, but that is because those organizations have a rule about who can coach or who can do this or that, or even employees certain employment and stuff, but that's not in our statute, if I'm understanding correctly.
Madam Chair, that's my understanding. It's not
Okay.
the statute, it's other, it could be other law, you know, federal law related to funding or state law related to funding.
Okay.
It could just be policy, because there are many restrictions that these same offenders would face, but they're not in the Offender Registration
I
Act.
see. Okay. Yeah, that's helpful. Committee, any other questions for Jason? Representative Goddard.
Thank you, Madam Chair. And thank you for the briefing. I was looking, trying to figure out a more concise definition of school activity. I can easily see a home basketball game, a home football game, or whatever would be a school activity. But what about away games? Students participating in competitions like, for example, the FFA and their speaking contests, et cetera. Would all of those be included as well?
Madam Chair, Representative, I think so. I think that's the intent of that definition. If you look at just the including but not limited to at the end, I think that's a good sampling of what is intended. You've got after-school tutoring, athletic events, school dances, social events, field trips, school plays, assemblies. So all of those things are contemplated as events that would be essentially off limits to these offenders.
Thank you. Thank you, Madam Chair.
Okay, committee, any other questions for Jason? Okay, thank you, Jason. We will go ahead. We do have quite a busy day. So I'm going to go ahead and call the proponents. We have a few in person and then several on WebEx. I'm going to ask you to limit your comments to 2 minutes, and then we will take questions after all the proponents have gone. Now, I know Senator Warren was here. She probably had to go. I don't know if the Senate is on the floor. Representative Estes, did you have kind of, I'm wondering if you're filling in for Senator Warren.
That wasn't my intention. I'd love to go to wait for a bill, but if you want why I filed the bill, I'm happy to say that, but
Did you happen to turn in written testimony?
I did not.
Okay, why don't we wait, and if you can stay for a little bit, we'll see if that works, if we can fit you in.
Thank you, Madam Chair.
Okay, I'll go ahead and do the people that sent in testimony. Okay, so then first will be Ed Klump with, you know who he's with, so.
I probably can't get off that easy, so I'm Ed Klump with the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. So just to be clear, not our bill. We do support the bill. I will say that there is a member of this committee that inquired about a bill like this shortly before this bill was introduced in both chambers. It is a statewide issue. We hear from people across the state periodically about this issue and concern. We think it is something that needs to be discussed and addressed. We like this bill because it's very narrow. It addresses a narrow band of offenders that have offended in a narrow band of crimes. And we think that's very appropriate for this. We've seen bills in years past. I don't think we've had a bill for several years on this, but some of them were so broad we could not support it. This is not that bill. This has good guardrails on it. And we think it is well put together, well constructed, and well targeted. And we think it deserves your consideration for passage. So to summarize, good bill, well written, vote yes. Thank you.
Okay, thank you so much. And if you can stay, we'll.
I will.
Okay, good. Welcome. Sorry, Representative or Senator Warren. Thank you for coming back. If you're ready, we'll just go ahead and have you come up. And we're trying to limit, about 2 minutes-ish. So thank you for being here. Welcome to your old committee.
Thank you, Madam Chair. It's great to be in front of all of you. I'm Kelly Warren. I represent Senate District 11. And this bill is the result of a registered sex offender was allowed to attend an elementary school parent-child dance in my district and not far from my home. So at the dance, the person was seen taking videos of kids who were not with him at the dance, other person's kids, and parents very upset and were concerned and surprised to learn Kansas doesn't have any restrictions on registered sex offenders, especially registered sex offenders who have the reason they're on the registry is because of a crime against a juvenile, someone under 18. So I was shocked to learn this as well. I'm a mom of 4 and I've had kids grow up in the school district there too, and I wouldn't want this happening to my kids, and I wouldn't want it happening to yours either. So with that then, I talked with these parents. I think some of them are going to testify today, and they can tell you in their own words how they felt about it, and have worked with the KNEA is in support of the bill. You heard law enforcement. We had many prosecutors on the Senate side. Senate heard the bill as well. The district attorney from Shawnee County, Johnson County, Sedgwick County, and I think some child advocacy centers are scheduled to testify here as well. So I think that a statewide policy is important, and it's pretty clear and black and white, and to because many school districts don't have any policy at all. And this was one where the principal at the elementary school had notification that the registered offender wanted to attend the dance. He was asking to attend the dance with a child that was not his own, and then was engaging in some activity that was very concerning to parents. So this is quite actually an example of government being responsive to a community need, and actually one that's across the state. So oftentimes we restrict felons from exercising other rights, the right to vote, the right to possess or carry firearms. So this would be one where it would behoove children, keep children safe at school. So I think the first thing you expect when you send your kids to school is that they be educated, and we do what we can to keep them safe. So with that, Madam Chair, I'm happy to stand for questions.
Okay, thank you. Do you need to run off, or can you wait a little bit? Or because we could ask questions of you now if you need to go on, get back to.
Sure. So I had just finished up carrying the 2 bills that I had on the Senate floor when I saw that your committee was hearing this bill. So I'm happy to wait. So if that
Okay.
would be the will of the committee. Thank you.
Great. If you can, that would be great. Thank you. Okay, the rest of the proponents are going to be on WebEx, and we're just going to go ahead and go through those. We have Steve Howe, the DA from Johnson County.
Thank you, Madam Chair. My name is Steve Howe. I'm Johnson County District Attorney. This incident referred to by Senator Warren occurred in my jurisdiction, and I am fully in support, as well as other prosecutors throughout the state. I had the pleasure of working on the Saki initiative, and many of you have heard me testify on another bill regarding that. And one of the things that that bill demonstrated is the high propensity of sex offenders to reoffend, especially when those commit crimes involving children. In the Saki initiative, the individuals that we were able to test the kits and be able to identify the perpetrators, the crime rates for those individuals, 42% of them committed other sex crimes, and 93% of them committed other crimes. And the Department of Justice indicates somewhere between 35 and 45% reoffending rates for these individuals. So there's a real clear need in order to protect the public, including individuals, our children, who are really the ones that these individuals prey on. This bill is tailored very specifically for pedophiles. If you look at the age scope, this isn't for adult offenders. This is for individuals who prey on children. And so to keep them away from school activities, school functions, I think is in the best interest of all Kansans, including our children. When you talk about individuals and their ability to go to school functions, with videos anymore, anything can be videotaped and then later provided to those individuals who may have kids in those school activities. But I think the needs of the public and the concerns of the safety of our children should be more important than the needs of sex offenders who want to go to school functions. And so I would ask that this committee pass this bill. It's a common sense bill, and clearly it's in the best interest of our children who attend a variety of different levels, K through 12. So I apologize, but I've got another meeting I have to go to, and I want to be available for questions. But if anyone has any questions, please feel free to email me at the office. I'll be more than happy to answer any questions at that time. Thank you for your time, Madam Chair.
You're welcome. Could you take one question?
Sure.
My question is, and I'm looking at your testimony, and certainly what you're saying is the very high recidivism rates for sex offenders that target young children. Child victim cases show the highest propensity to reoffend. And is that, what would you call young children or child victim? I mean, the bill says under 18, and I'm just curious if there's any data that shows, under 14 is a higher recidivism rate, or younger, which is just hard to think about. But yeah, do you
Yeah.
have any data about that?
The data typically says minors or children. And so typically minors in most states, you're talking about 16 or under. And so pedophiles, there's a wide variety of them. Unfortunately, we see some that are really, their fetish is young children, under the age of 8 years old. And then others perpetrate on teenagers, young teenagers. And we see both of these types of situations, but typically the statutes in studies typically use 16 or younger as children under state statutes.
Okay, thank you. Thank you. I appreciate that. All right. Thank you. Okay,
Thank
next we
you.
have, appreciate you being here. Kim Bergman, private citizen on WebEx. Hi, Kim, are you with us? You sure can.
My name is Kim Bergman, and I support House Bill 2404. I'm the mother of 2 young boys who attend public school in Johnson County, Kansas. I'm also a survivor of child sexual abuse myself. I was 12 years old when my gymnastics coach, David Bird, began sexually abusing me. Sexual predators rarely stop after one victim. Over the years, I have learned that I'm not his first victim or his last. There are at least 11 of us that we know of who were abused over the course of 20 years. There were 10 years between myself and the last known victim. I can only imagine how many of us there really are. My coach was finally convicted of abusing a child in 2008, but only served 2 years for his crimes as a first-time offender. He was never held accountable for abusing me or the other 9 victims due to the statute of limitations. David is now free in Wyandotte County, living with his new wife and her grandchildren, and recently told a former gymnast of his that he might see her around at her daughter's gymnastics competitions. Despite being a convicted sex offender, he has no intentions of staying away from children. Child sexual abuse can happen anywhere that predators have access to children. Predators are often difficult for parents to identify. They convince their friends, family, and everyone around them that they are trustworthy and that they would never hurt a child. Why else would parents allow them to be around their children? As a mom, I would feel safer sending my kids to school, knowing that the spectators watching their swim meet haven't been convicted of possessing child sexual abuse material, that the parent helping with the Halloween party hasn't been convicted of soliciting a child for sex, or that the parent sitting at the lunch table where my child is wasn't given a plea deal after molesting their niece at a sleep. Our children from all the unknown dangers in the world. That House Bill 2404 would allow us to at least take a step in protecting them from a known danger, the convicted predators who have already been determined to be a danger to society. Why else would the courts post their names and pictures on the public sex offender registry? Thank you, and I hope that you all support this bill.
Thank you, Kim, and you're able to stay around if anyone has any questions.
Yes.
Okay, thank you so much. Now I'll call Coulter Daubert, private citizen. Coulter, are you with us?
I am, thank you.
Yep, well, you have about 2 minutes is what we're trying to shoot for.
All right, perfect. Well, first off, good afternoon, everyone, and God bless you. I'd like to start by saying thank you for allowing me to be here today to give my testimony. I am here on behalf of my two daughters, one who's 13, the other one who's 9, and my son who is 5 years old. They all attend the Blue Valley School District. And unfortunately, I was there the night that the incident happened that Senator Warren was speaking about. And after that night, the very next Monday, the school board had a meeting where they specifically stated that they didn't do anything wrong because there's nothing in the state that would say they did something wrong. So the minute that I heard that statement, that's when I knew I had to be an advocate for my kids and the other kids in the school district and the state of Kansas. As a lifelong Kansas resident, growing up in Southwest Kansas, a small farm community, I actually thought that no one registered on the as a sex offender was allowed to attend any school or even live near a school. So it was to my surprise when I found out that that was not the case here in Kansas. And after doing lots of research and starting to work with other parents to find out the best way to go about this, I found out that most of the people that I interacted with, especially on social media and in the public, were absolutely shocked that we didn't have something in place either. And I do understand that one of the concerns was, well, what if this gentleman wants to attend that school event, or in the future he wants to go to more events? Well, my response was, don't break the law, and then you get to do those things, and don't harm little children. So I'm here today to ask you to please vote yes for this bill. I think it's going to protect children. And again, I think it's important to understand that it's geared toward people that have abused minors. I think that's very important. That gets lost sometimes in the conversation. And, you know, I also
If
found
you can
out that,
kind of wrap it up, that would be great.
yep, no. Again, I just appreciate your time, and I hope you support this bill. Thank you.
And if anyone has any questions for you, I'm assuming you're fine to answer
Yes.
questions? Okay, sounds great.
Yep.
Thank you. Okay, we now have Jessica Daubert, private citizen. Jessica, are you there?
I am here.
Okay, great. Thank you. Welcome to committee. You have about 2 minutes.
Okay. Thank you, Madam Chair and the committee. My name is Jessica Daubert. I am a state of Kansas native, and I currently reside in Overland Park. And I am the wife of Coulter Daubert. You just heard him spoke about what got us into this this journey to get a bill approved to ban registered sex offenders from attending any school functions. And we hope that we can also make it to where the registered sex offenders cannot live within a certain distance of schools. Like what Coulter had mentioned, a lot of us parents were completely surprised. There were school board members that were surprised that there is no law in Kansas. A lot of us parents were under the impression that it was just like Missouri, where the registered sex offenders are not allowed to attend any school events, any school functions, anything on school property, nor are they allowed to live within a certain distance of any schools or daycares. So our surprise was that we felt defeated, we felt helpless, went to the school board. The school board kind of swept it under the rug, did not want to be the bad guys to make the decision nor say anything. So that's why we are very glad that you guys were giving us the opportunity to plead our case. I know that there's concerns about offenders who are attending schools, but all juvenile offenders, from what I gather, who are required to register in the Kansas Offender Registry Act, do not appear on the actual registration website because they are minors. In certain circumstances, I know that they were worried about children that were between the ages 18 and 21 who were in IEP programs, who were still attending schools, that were on special programs, but those programs are obviously closely monitored. I mean, they're there on a special program. And I feel like this bill that we are trying to pass should not be affected to them in any way, shape, or form. Traumatizing children for sexual purposes is one of the most heinous crimes that has ever been investigated. Protecting our children against sexual predators and achieving justice for the victims and for those crimes should be the highest priorities in the state of Kansas. There are a reason why most child sex offenders are kept in special units and away from other criminals in jails and prisons. No one likes or trusts child harmers, and these statements come from some of the most violent offenders, according to
Jessica,
numerous.
if you could sort of, just give us your main points and kind of wrap it up, that would be great.
Okay, great. So what we're hoping to do is just to get this bill passed and hope that other testimonies, that other people that are against it, that, seem to try to put into perspective that there's a one-time offenders that they're talking about, and that is not the case. They're trying to make sure that the sexual offenders do not get left out of society or their children's gatherings, but what about the victims and what about my child? What about my children and her peers? It just seems unfair that they have more freedom and more rights than us parents who are trying to protect our children at all costs when they're especially at school, where we are not able to fully protect them, but we're leaving it up to teachers and principals to do so for us. The school board does not wish to make any changes, so we are relying on the state of Kansas to make the changes for us and for other school districts. It's not just about Blue Valley Middle School or Blue Valley School District in general. It's about all of the schools in Kansas that would really like to see this change happen. Thank you for your time.
Okay, thank you. Appreciate it. Next, we have a Blue Valley student, private citizen. No? Okay. Okay, we'll go ahead and do Christine Antes, private citizen first, and maybe come back to the private citizen. You can come down.
Hi, Madam Chair and committee. Thank you for hearing me today. I'm Christine Antis.
Wait just one second. We can't see you yet. There you are. Okay, great. Now
I'm so sorry.
Okay, Christine, thank you. We've got you now. Thank you.
Thank you, Madam Chair and committee. I'm Christine Antis, and I'm a mom who's urging you to enact laws like those in Arkansas, Missouri, and Florida to ban or restrict registered sex offenders from our school. As you've heard from Senator Warren and the Daubert family, they've mentioned that this happened at my son's elementary school. And I just wanted to cover that the sex offender who attended was convicted of distribution or receipt of child pornography via the internet. He was observed using their cell phone application directed towards students on the dance floor. And again, no Kansas law or district policy was broken. Per a Fox 4 News report, detectives found hundreds of images, including a 6 to 8 year old being sexually assaulted. This individual is on the registry for 17 more years, yet free to enter schools. The Kansas Bureau of Investigation reports 12,139 sex offenders statewide. Research documented in the law and human behavior shows reoffense rates climb from 4% in 4 years post-release to 25% by year 15 post-incarceration. This supports what Steve Howe had testified. The Journal of Interpersonal Violence notes that child sex offenders use manipulation to groom kids and to exploit parents' trust. This behavior makes sex offenders dangerous in settings such as schools where trust is assumed and vulnerabilities are abundant. These statistics and traits compel us to act proactively and not reactively. I support HB 2404, but I would like to suggest that the 18 to 21-year-olds with IEPs can access education under strict safety protocols to keep classmates safe. And I appreciate and thank you for drafting this bill. Thank you for your time and consideration to allow our schools to be safe and not vulnerable.
Okay, thank you. And Christine, you're able to stay around a little bit if anyone
Yes,
has
I
any
can.
questions. Okay, that sounds
Thank you.
great. Thank you. Okay, we will now go back to our Blue Valley student, private citizen, and we're just going to keep the video on us because it's anonymous. So, okay, if you would go ahead, can you hear us? Student? It seems like maybe you're muted. Nope.
Yes, I can
Here
hear
you
you.
are. Okay, I think we can hear you now. Go ahead. We are listening. Welcome to our committee.
Thank you. Hello, I am Blue River Elementary student. I come to you to speak for all children to protect them in school activities, and learning. Because if you are in school and someone that has hurt people, would you let them be or stand up for the people demanding an end? That's why I'm standing up for all children. Do you really think that I would want a bad person watching me for an inappropriate reasons? Do you really think that I would want a bad person taking pictures of me and my friends while having fun at a school dance for inappropriate reasons? Help protect us children while we are trying to learn at a unprotected school, unprotected district, unprotected state. Sincerely, a Blue Valley District student.
Okay, thank you. We appreciate you coming and giving us your perspective. Thank you for that. Okay, committee, we are now going to I'll ask the committee if you have any questions for any of the proponents. Representative Vaughn has a question, and if you know who you would like to answer it, just go ahead and direct your question there.
Thank you, Madam Chair. I think maybe Senator Warren, if I could ask you a question. I appreciate you bringing this issue to us. I'm generally supportive. I think my my only questions are around some of the broadness that was previously discussed by some of the conferees, but you know, so curious, is there conversation about some kind of amendment for students who are 18 to 21, kind of in that potentially that IEP program, potentially with additional safety protocol, but looking at some kind of amendment for that group? And then I also had questions or was wondering about situations in which other students aren't present. So if it's a parent and they want to be, you know, still active in their child's education, like a student teacher conference where other children aren't present, or maybe just like school pickup if they're in the car and they're dropping off or picking up their own child. Or in a different scenario, if a school property is a polling location, for example, and that's where they go to vote, but there aren't children present. Like, I'm just curious if there are specific carve-outs that are being considered for those types of scenarios or potential amendments.
Thank you, Madam Chair, and thank you, Representative, for the question. So the Senate Judiciary Committee heard the bill as well, the exact same language, and we did pass it out favorably out of committee today. And the only amendment that was on the bill was regarding really the ability to homeschool your own child. If you're on the list, you shouldn't be prohibited from homeschooling your own child. Or I don't have a copy of it in front of me, but if it's a small enough homeschool situation, I think it was 9 students or less, it wouldn't apply to that situation. But that was the only amendment that was made in committee. And I would share that regarding the polling place, I mean, like I said in my testimony, we restrict the ability of felons to vote completely. Sometimes you can't vote. We restrict the ability to possess or own firearms. So if there's a polling location at a school, we didn't hear any weigh-in from the Secretary of State that that would be a problem. And I would think that the local jurisdiction could, I think they're going away mostly from having polling places at schools. And in addition, in Kansas, you know that you can mail in your ballot. You know that you can turn in your voted ballot to someone else to go deliver for you. You know that you can drop it off at a drop box at the election office. In our county and in any county in Kansas, you can vote at places that aren't your designated polling place as long as you're voting not on election day. And so there are many options to get your vote turned in, even if it's not at your particular polling place. And I would think that that would be available to those folks. Regarding the IEP, I mean, we heard some testimony, as you'll probably hear, from the Kansas Association of School Boards. The Kansas Association of School Boards was neutral on the bill except for, well, what do we do about the 18 to 21-year-olds? Well, you saw that it came out of Senate committee and we didn't amend for that situation because it was a policy decision that, quite frankly, there need to be made some other accommodations. If you're on the registered sex offender list, maybe you shouldn't be with other 18 to 21-year-olds in the schools. And regarding your other question, drop off, pick up, other things. When I was at the school board meeting the Monday that I think Mr. Daubert talked about, I presented the draft of the bill. I said I have a draft that I've drafted in response to this February event, and I shared it with the school board and the superintendent as well. And they were actually, it seemed pretty relieved that there wasn't any discretion, because once you get into discretion, well, do you have to then determine your offense was 10 years ago, so it's okay for you, but your offense was 1 year ago, so it's not okay for you, or your offense was this, so it's okay for you, but not for you. And also it creates some different liabilities for our school districts. If you're letting someone on, though you've put supervision in place, well, what if the supervision goes awry? And then our school districts would be in a difficult position. So it seemed at the time that with the very narrow, I think our district attorney used the term pedophiles would be restricted from entering school property or school activities, that it's in a good place and pretty clear for everybody.
Thank you. I appreciate your feedback. I guess I just disagree. I think there is a lack of clarity, although I agree with the underlying premise of the bill. I do, and we have to protect kids, but we also have to protect people's constitutional rights. And I think that that has to be considered if they're not, you know, a convicted felon, or it just, you know, they still have a right to vote, for example. So I think there are scenarios that potentially should be addressed. So anyways, I appreciate your feedback. I agree with the underlying bill. I just worry about some of those issues I raised in particular, but thank you.
Okay, thank you so much. Committee, any other questions for the proponents? Okay, thank you so much. Oh, I'm so sorry. Representative Martinez.
Thank you, Madam Chair. I have two questions, I think.
Go ahead, yeah.
Okay. I don't know who this one would go to, but first, I also agree with the underlying bill, but I have some issues with it also. What kind of data is there that someone might have to reflect maybe offenses that have occurred at school with these sex offenders, reoffending at school events and things like that? Is there any data that can tell us that this has occurred, that this is a problem?
Yep, go ahead.
Thank you, Madam Chair, and thank you, Representative. So I think the best person to answer that question would be District Attorney Steve Howe, although I think he said he was unavailable. But I'm happy to look into that with him further for you. And just want to remind the committee that the persons who would be on the registry for sex offenses include criminal sodomy, indecent solicitation of a child, indecent liberties with a child, sexual exploitation of a child, aggravated human trafficking, aggravated indecent liberties with a child, aggravated indecent solicitation of a child, aggravated internet trading in child pornography. So with the bill as written, you know, it's too easy to take your phone out and take a picture of somebody while you're helping with reading games in class or something. And I think that you're on the registry because you have been convicted or you have entered into a plea agreement. So you're not on the registry by accident. You've been proven guilty beyond a reasonable doubt, or you've entered into that agreement. And we have to remember, these were specific offenses that you're on the list for because a child victim was involved.
And I understand that, as far as being able to, and maybe that would be something that, I don't know if they could amend and maybe not allow them to have cell phones or anything like that, you know, on their person when they go to these events. Another concern is you have offenders that have children, and they go to their ball games, and they go to their graduations, and they go to their student conferences. So the child is paying for their parents' offense too. And I think it's important that we consider the students that have parents that have done this. You know, it's unfortunate, but they're paying for the offense also, and it's important to their growth and their security and their emotional and mental well-being that their parents be there for them also. So I think I just have a problem with these individuals not being able to attend student conferences and just the really key moments in a child, you know, student child's life, where, you know, you want your parent at your conference, you want your parent to go see you at your ball game, you want your parent definitely at your graduation. So those are important moments. So I think that's my problem with the bill itself.
Thank you, Madam Chair, and thank you, Representative. And while that parent would be prohibited from attending the child's school activities, what about all the other children who are at risk, not knowing who the offender is, not knowing that there's a present danger at the school activities, at the swim meets? You heard from parents testify. And I think we have, as a state, an obligation to make sure that those unknown dangers regarding sex offenses against children or other offenses against children, they would be sex offenses, that we're keeping the other kids who attend school and aren't with their parents necessarily, or even with parents at the school activities, that they not be subject to a predator who's there who might be engaging in activities that would be harmful to the other kids. Regarding your question about conferences and Representative Vaughn's question about the car line, well, if you're in the car line, you have a cell phone and you might be taking pictures of other kids in the car line. We know with AI, you can take that child's face and make it with AI look like it's doing some improper activity. Regarding teacher conferences, I know a lot of districts have online teacher conferences, and sometimes that's the preferred method. So you don't have to be on school property to still engage in some of those activities. I know with IEP meetings, as long as one parent is present to attend the meeting, that would be, you've conducted then notice and with the parent present, the IEP meeting. I think that you'll hear from the Kansas Association of School Board. I think they're testifying that notice is even given to parents who are incarcerated, who are in prison, about, hey, there's an IEP, can we get you to attend online? So there are many different options. And remember, we're keeping the general, the kids at school who don't know about the registered sex offender, keeping those kids safe.
Representative Bohai.
Thank you.
Thank you very much, Madam Chair. Fast question, I think. Is this only for offenders on the sex offenders list, or is this for other offender lists as well?
Jason.
Thank you, Madam Chair. So it's lines 8 and 9, sex offender, 18 years of age or older, underlying crime requiring registration, had a child victim.
Thank you.
Okay. Representative Estes, I'm going to give you just a minute.
Thank you, Madam Chair. I just wanted to say, when this situation arose, I equally was shocked and felt compelled to take the law that Senator Warren put together and bring it here, because there is no way, no matter what stipulations that we put in, that I can sleep at night knowing in believing that we have created a totally safe way to do it, because that risk of reoffending is so high that I think we have to always err on the side of protecting other children. And I think we can look at a lot of different ways to do some of the things that we need to do, especially conferences through a digital means and so on. But I just can't let some child take the risk that we didn't see a phone come into a swim meet or a gymnastics meet or something like that. And I think this is very important. Thank you, Madam Chair.
You're welcome. Okay, committee, I'm going to go ahead and Representative Barrett, go ahead. I didn't see your hand.
It's okay. Can I ask Ed Klump a question, Madam Chair?
Yep.
Yes, sir. Ed Klump with the Law Enforcement Associations.
Thank you. Mr. Klump, I know you've had quite a few years in law enforcement, correct?
Yes.
In your experience in law enforcement, have you seen cases where pedophiles will intentionally seek single mothers who have kids to exploit those children, or vice versa, they have children so they can exploit those children?
Well, you see all kinds of scenarios like that. I'm sure those are included as well. I mean, that's the problem here. I think this bill tries to address is they try to seek out an environment where they can have contact with young children, and that's the problem we're trying to prevent.
Thank you. And I only ask that because we've seen that here locally. So thank you, Madam Chair.
You're welcome. Okay, committee, we are going to go ahead and hear opponent testimony now from Grace Tran from BID's Legislative Committee. Welcome to our committee.
Chair Humphreys and members of the committee, my name is Grace Tran. I'm an attorney with the BID's Legislative Committee. We stand in opposition to this bill because we don't believe that it will decrease recidivism, and we think that it may even actually risk increasing it. We weren't able to find specific statistics about school-based restrictions, but there is a lot of research about similar residency restrictions. So that's making sure people can't live within certain amounts of feet of schools. And these statistics actually come from the Department of Justice's Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking, SMART. They evaluated residency restrictions and found no empirical support for them. They said that they did not believe at that time that they were recommended. And some of the studies that they based that recommendation off of found that vast majorities, and for two studies, for example, over 80% of sex offenses, including recidivist offenses, took place in residential or private settings. And so for that reason, we think that these types of restrictions would not be effective in decreasing recidivist rates. And in that same report, they cautioned against these types of restrictions because of an increased risk of recidivism due to isolating people from their social support networks and their communities, and that those types of restrictions would, yes, isolate people and lead to, less support and less structures that would keep people successful in their recovery and rehabilitation and ability to stay out of trouble. And I think the same sorts of concerns are relevant here. Many of those have already been addressed, but parents not being able to go to student-teacher conferences, not being able to drop off their children at school, be involved in sports games, activities. There was a man on the offender registry list who testified for Senate Bill 288. He was a single father on the registry, and he testified that it would totally make him unable to be present in his child's life, educational life. We'd also like to note that many people who are required to register had their terms of registration drastically changed by 2011 amendments to the registration statutes. Many people's terms of years drastically increased or went to terms of life. If this applies retroactively, this would be yet another significant change with no process, no individualized assessments, no warning to these people. We ultimately just want to emphasize that these people are members of our community. They've either served their time or they were not sentenced to prison at all. The registry is wide-reaching. People register as sex offenders for things that are low-level felonies, misdemeanors, not sex offenses at all, like theft with a sexually motivated finding. People convicted of high-level offenses are sent to prison, where they have long sentences and are prevented from getting dispositional departures to probation. Ultimately, we just think that it's in the best interest of all the members of our community to support policies that promote rehabilitation, and we respectfully don't believe that this does that. So we stand in opposition, and I will stand for questions at the appropriate time.
Okay, thank you. Committee, do you have any questions for Ms. Tran? Representative Barth.
Thank you, Madam Chair, and thank you as well. I wanted to ask a little bit about the fact that you don't support this bill and that typically the offenses of a child sex offender happen in their home. Don't you think that if they're going to school events with children who are their folks that they prey on, that maybe they are trying to bait and lure children in those school settings?
I mean, I think the statistics show that overwhelmingly these types of offenses don't occur at those types of settings. And we'd also suggest that as has been identified, there are a lot of reasons why people would want to go on school property. They have children that they'd like to attend events for. They'd like to vote at their local polling location, which might be a school. They'd like to attend a church service that is on a school property. So I don't think that we can say with any degree of certainty that the only reason people might want to go on school property is to prey on children.
Committee, do you have any other questions for Ms. Tran? Representative Goddard.
Thank you, Madam Chair. I don't believe that this bill was intended to decrease recidivism. It was intended to protect the children in schools and school activities. Could you make a comment on that, please? Because your testimony talked about recidivism and decreasing that. I thought there are other agencies who would treat that.
Sure, and we might be having just a difference in terms that we're using here. I think my point would be that if the bill is intended to keep people off of school grounds and to keep children safe, that would be to prevent recidivist sex offenses by people who are on the registry. So I think that we're talking about the same thing here. I think it might just be a matter of terminology difference.
Madam Chair, respectfully, I disagree with you, and we'll leave it at that. Thank you. Thank you, Madam Chair.
Representative Carmichael and then Sweeley.
Thank you, Madam Chair, and I appreciate you being here and bringing us the other side of the story, as Paul Harvey used to say. I listened to my friend Representative Goddard's question about recidivism and reducing recidivism. I guess honestly, I'm not following my friend's question, so let me at least try to ask the question of you. If the objective is to keep people on the registry away from children, I assume that the objective is to therefore deter people on the registry from committing crimes against children. Would that be your understanding?
Yes, Representative, that's how we see it.
And if we deter someone from committing a crime against children, then we prevent recidivism. In other words, people who've already been convicted of the same or similar crime from doing it again. Is that your understanding?
Yes.
And so whether we say the purpose is to protect children, which undoubtedly it is, we're saying we don't want these people who are on the list to reoffend, hurt children, and be recidivists. Is that the logic?
Yes, that's correct.
Thank you, Madam Chair.
Representative Sweeley.
Thank you, Madam Chair. Thank you, Grace, for being here. So in the statistics that you showed, is 82.2% of sex offenses occurred in a private setting, while another found that 85% of recidivist sex offenders occurred in a residential location. So what about the other 15 and 17.8%?
You know, we think that going off of the statistics, you know, greater than 82, greater than 85, we we have to also look at, again, the other concerns that we've raised of the ways that this could increase risk of recidivism for people. And although there is, small percentages of these offenses that occur in non-private or non-residential settings, that doesn't necessarily mean they're schools, for one. And also, this does risk increasing recidivism everywhere. So we think that, the statistics bear that out.
By hurting these offenders' social skills or their feelings or what? How does it increase it?
So the idea is that when we force people into the margins of their communities and decrease their abilities to be parts of their community, and in this case specifically be parts of their family, that undermines stability in their lives and increases their risk of acting out in obviously behaviors that we don't want to see, like hurting children.
If I may, one more. So are you saying that the BIDS Legislative Committee is okay with a grown man taking pictures of middle schoolers in a middle school dance?
If you're referencing the event that took place at the Blue Valley Dance, my understanding based on the reporting
that are not his kids.
My understanding based on the reporting that I read was that they could not confirm whether or not he was actually taking pictures. It was that he was pointing a phone at children.
If he was taking pictures, hypothetically.
Hypothetically, we would respond that it's not illegal to take photos.
So you're kind of sitting on the same point that you guys testified a month and a half ago, that if you find AI-generated child porn, just because you find it gross, it shouldn't be illegal, correct?
In that bill, we believe it was a First Amendment unconstitutional.
I know where you stand. It's fine. Thanks.
Representative Barrett.
Thank you, Madam Chair, and thank you for coming to committee. I guess, so the data is pretty strong when it comes to particularly offenders who are going it for prepubescent kids, that they can't be fixed. No matter how much counseling they go through, nothing's going to fix them. They're broke. So in that circumstance, why should we not be able to at least prevent those people from entering our schools? And I understand, you mentioned recidivism. If they're not in the school, they can't offend in the school. So can you just kind of respond to that and help me understand why we shouldn't keep them out of our schools?
Again, I think I would just point back to the data that suggests that the vast majority of these offenses take place in private settings. And so there's nothing to show that this would be effective to reduce new offenses occurring.
Okay, committee, I think we're going to thank you, Grace, for being here. We're going to go ahead and have the neutral testimony. Shannon Kimball from the Kansas Association of School Boards. Thank you for being here. And go ahead and give us your testimony. We're hoping it'll be a few, give us your high points.
Try to be brief.
Yes.
Thank you, Madam Chair, members of the committee. Shannon Kimball. I'm the Government Relations Specialist with the Kansas Association of School Boards. For those who don't know our association well, we represent 285 districts, about close to 2,000 school board members across the state. Given the safety concerns that have been brought forward in this situation, we understand the legislature's interest in acting in this area, and it aligns very closely with our member-adopted policy around school safety and security, providing safe and secure environments for students. And it does so without creating unfunded mandates or placing added administrative burdens on school districts to implement the law, which is a positive. We appear as neutral today because we also have legislative policy, which is member-directed in our association, around cautioning the legislature around creating situations where districts are faced with conflicting mandates in the law. And so there are two of those situations that I just want to highlight, and they've both been mentioned already, but to fully brief you on our testimony. One would be the situation where we are legally required to provide an education to students who are older than 18. So you could have 18 or 19-year-olds who in the regular course of their education haven't completed high school. 18 to 21-year-olds who qualify for special education services under an IEP until they either graduate, complete their program, or age out of the IEP services. And also some districts, not all districts, but some districts in Kansas provide adult education and GED and diploma completion programs in their communities on school district property. So in those circumstances, we think there could be offenders entitled legally to those services, and then the districts would be faced with a potential situation of having to figure out how to address those conflicting mandates. And then the other situation would be under IDEA and other circumstances where parents are considered to have a right to participate in their students' educational services, and just figuring out how to enforce the requirements of the bill as it's been proposed in those kinds of circumstances. That's all. I am happy to stand for questions, and thank you for your time today.
Thank you so much. I'm going to go ahead and ask you a question, if I may. We had heard that from a private citizen that they felt like the Blue Valley School Board would not act and would not protect them, so they were happy that the state was doing something. And I read in the Wichita Public Schools, they already have a policy in place. They're committee neutral, written only, but I knew that they had a policy in place to deny access to registered sex offenders while the students are present. And so tell me about what, is it good for district by district to do this, or is it a statewide mandate good, and thoughts about, Blue Valley not wanting to wade into this, or, just a little, if you enlighten us a little bit about that.
Sure. So what the circumstance you describe is one of the beauties of local control, in the sense that districts do have discretion to act in certain areas. And in this case, it sounds as if the Wichita district has adopted board's policy, and that action would be available to any school district in the state within the law to adopt a policy like what Wichita has adopted. I think that is that better than having a statewide mandate? I think that's a policy decision for the legislature in this particular circumstance, and really our purpose in providing testimony today was simply to point out that there might be some circumstances that are difficult for districts to comply with all of the mandates that are on them if you do choose the route of adopting state statute on this matter.
Okay, thank you. Committee, do you have any other questions for our neutral testimony for Ms. Kimball? Okay, I guess not. Thank you so much. Okay, committee, I will draw your attention to written only testimony, a proponent testimony from several groups and private citizens, and also neutral written only, also from the Wichita Public Schools that I mentioned earlier. Do you have any other questions on HB 2404? Okay, seeing none, I'll close the hearing on House Bill 2404, and I'll open the hearing on Senate Bill 237 and ask Jason, our advisor, to give us a bill brief.
All right, thank you again, Madam Chair. Jason Thompson, Revisor's Office. Senate Bill 237 comes to you via the Senate Committee on Judiciary and passed the Senate after some amendments, 40-0. The bill requires the court to consider the value of individual retirement plan accounts in determining child support under certain circumstances. It mandates the use of those accounts to pay child support arrearages under some circumstances, and it eliminates the exemption of individual retirement accounts and similar instruments from claims to fulfill child support obligations. Those are the three kind of main points of the bill. Section 1, which is part of the Family Law Code, 23-3002 is about child support, and that's where the first provision is added, saying that the court shall take into consideration and order the use of individual retirement plan accounts if, and here are the certain circumstances, if the person has experienced a loss of income or termination from employment due to loss, revocation, suspension, or surrender of a professional license because of professional misconduct, or voluntary underemployment. So under those circumstances, the court would be considering retirement accounts. You'll notice that if you look at the bill, One of the things the Senate committee did was remove criminal conduct. There was some discussion in the Senate about how that would create a conflict of law, I believe. But criminal conduct is not in here. It was in the original bill, and the conferees might be able to get into that if you need some information, but it's not in the bill as it comes to you. The other provision here in the first section is specific to arrearages. So if a parent accumulates a child support arrearage, that is when, due to those circumstances we just talked about, losing their license because of misconduct, voluntary underemployment, then the court is required to order use of those funds, but only after the amendment in the Senate Committee of the Whole, in the Senate Committee, upon the occurrence of a distributable event as defined by the terms of the qualified plan. So when one of those events happens, that's when the court would order you to use those funds to pay that arrearage, the fancy word for you owe child support, and usually lots of it to get an arrearage. There are some other provisions I won't get into. They're kind of technical about what happens when you use those funds, right? Lump sum, distributions that are not authorized by law, because these are retirement plans. They have special legal requirements related to them. So I won't get into the details of that. This is my first year on House FINP, and so I'm not really the person to talk about that, but I do kind of understand the concept here. Those are meant to facilitate use of those funds without making you break federal law or other state law. That's the kind of high-level overview of what's going on there. Section 2 then gets into 23-3005, which is still about child support, and defines material change in circumstance. So that is there on page 2. And the reason for that is current law says you can authorize, the court is authorized to modify orders within 3 years of the date they're made when there is a material change in circumstance. And one of the things that would be a material change in circumstance would be loss of your professional license or voluntary underemployment, which would affect your income. And then finally, Section 3 is up in the Civil Code, 60-2308. This is the one about exemptions. Pension and retirement monies are exempt from certain claims and orders. And there's an amendment here to make clear that retirement plan accounts under several sections of the Internal Revenue Code are not exempt from claims under the child support orders that we were just talking about. So that, I think, covers kind of broad picture what's going on. It would take effect upon publication in the Register, so not July 1st, but publication in the Register. And I'll be happy to answer questions if I can.
Okay, thank you. Committee, what questions do you have for our reviser? Okay, seeing none, thank you, Jason. We will go ahead and call Josh Nye from Kriegshauser Nye Law Group as our only in-person proponent. Thank you for being here. Thank you for waiting for this hearing to start.
Glad to be here. Thank you, Madam Chair and members of the committee. Josh Nye with Kriegshauser Nye Law Group. My partner, Ryan Kriegshauser, is behind me. We became aware of this bill. I was aware as it kind of went through the Senate, saw it pass 40-0. And then some people who were unable to be here today asked me to take a look at it and at least be here as an attorney that could provide at least someone to ask questions of. I don't know if that was a good decision or a bad decision, but I'm here. I found it interesting on the Kansas Judicial Branch website that there's a frequently asked questions, and one of the questions that they put on there regarding child support is, why are the guidelines so complicated? And the answer on the Supreme Court website is they were much simpler when they were established in 1987. Since then, the advisory committee and the Supreme Court has listened to parents, judges, and attorneys and added rules that allow judges to consider many special circumstances before ordering child support obligations. And then it says, what is the economic basis for the guidelines? It says the math behind the guidelines is complex and requires an understanding of power functions, linear equations, and logarithms. I found that interesting that even for parents going on the website trying to navigate this of what's included and what's not included, that there's kind of a warning up front that this is going to be kind of hairy as far as what a judge can take into account and what not. So I think this bill, and the reason that I stand in support of it is because I think just zooming out a little bit and asking what is equitable, what's fair, if the idea of child support is if you are a parent to a child, you have a responsibility of supporting that child first and foremost, even before your own your own support, so to speak, when it comes to discretionary functions. And I would say that at least with respect to retirement accounts, obviously that is set aside for your future care and support, but the children who are minors or dependents have need for child support today. So I ultimately think when we zoom out, this is a good bill to allow judges to take into account retirement accounts and court-ordered distribution of those retirement accounts under the 3 different criteria that Jason listed earlier. Ultimately, looking at the whole pie of a parent's income and assets in order that the children come first during their years of dependency. With that, I would stand for questions.
Okay, thank you so much. Committee, do you have any questions for Mr. Nye? Yes, no? Okay, I don't think so. Senator Warren, would you like to say something?
Thank you, Madam Chair and Committee. Kelly Warren, representing Senate District 11. Apologize, I didn't get my testimony turned in. It's a busy time of session, but Mr. Nye did a great job. We did hear this in Senate Judiciary, and it does address the concern. Well, you're a parent, you've got arrearage, means you owe child support, you're late on it, you're not keeping current, and you then have your retirement account for yourself to provide for yourself for the future, but you have an obligation to support your child that's overdue. And this would create an opportunity to get some of that arrearage and get that paid. It was, we did have some capers testimony that we were able to then amend the bill in its current form as it comes to you to address those concerns. And we did have some concerns from DCF about the criminal conduct being included in the bill. So we addressed those as well, and that's why criminal conduct is out. So both of those amendments were acceptable to capers and DCF, and I think DCF in fact said, well, this will actually help us enforce some of those arrearage orders and get them collected. So with that, I'd stand for any questions. Thank you, Madam Chair.
And do you think you could just provide some simple written testimony for the website? That would be great.
Absolutely, thank you.
Any questions for either proponent? Okay, seeing none. Any comments from the? Okay, just making sure that, okay, committee, we have proponent written only testimony from Lucretia Nold, Brittany Jones, Dodie Welshire, and Alana Zimmer. We don't have any opponent testimony or any neutral testimony. And with that, I'll close the hearing on Senate Bill 237. I will just go ahead and get one little housekeeping thing out, and that's we need to approve our minutes. And we have January 15th, 21st, 27th, 28th, 29th, and March 4th. Thank you, Lene, for getting that done. Did anyone notice anything that needed to be changed in the amendment, in the minutes? Okay. Okay, Jason sent a few. Okay. So let's say, do I have a motion to approve the minutes as amended by our advisor? Representative Williams, do you have a second? Representative Schreiber seconds that. All those in favor of a
Discussion, please.
Oh, discussion?
Thank you, Madam Chair. I've not had an opportunity to read or review the minutes. I don't want to delay the progress here, but I want it publicly known that I've not read them. I haven't looked at them, don't know whether they're accurate or not, and I will not be voting on the motion. Thank you.
Okay, thank you for that honesty. Appreciate that. Okay, any other comments on the approval of the minutes as amended? Okay, then all those in favor say aye.
Aye.
Opposed, no. Those minutes are approved, and we will have a few others maybe tomorrow. Let's see. Okay, committee, we are going to try and just get a few things done. I'll pick out a few that I think we can get done fairly quickly. I'm going to start with Senate Bill 70. Not the quickest one, but I think it's one that there will be maybe a little bit of discussion, but should be okay. So, Jason, can you tell us what Senate Bill 70 is about? We had the hearing on March the 12th.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So this is the bill that is about open government. It has several pieces. There's the piece under the Open Records Act prohibiting fees for electronic copies of records, and the piece exempting from disclosure some formerly closed investigations with no found violations. The piece about requiring district attorneys to file reports of violations of COMA and CORA with the Attorney General in October instead of January. And then in the Open Meetings Act, there is a provision about membership calculation of subordinate groups like subcommittees. And then there's a provision about live streaming, ensuring the public is able to observe all parts of live streams. And finally, in COMA, about a 5-minute deviation or grace period for Open Meetings Acts when you go in and out of executive session.
Thank you, committee. We're going to have a discussion on this, and I'm going to go ahead and offer an amendment to this bill. Jason, you can be passing it out. I'll begin the easy part of the explanation. You all know that we had a CORA bill that had to do with the charges, and so we're simply dropping the contents of House Bill 2134, which we approved, and it was passed out of the House. We're dropping the contents of that into their CORA piece. So what we've already approved, we're going to put, instead of the way they had the CORA fees and charges, we're going to use what we had decided as a committee would be the fees and charges for CORA. Jason, do you recall on the House floor how the votes on 2134? Okay, he'll get that for us. Okay, Jason.
Madam Chair, it was 123 to 0.
Okay, 123 to 0, just so you all know. So we're dropping that piece, our piece, into this Senate bill. The other thing that we amended, the House bill is attached for you to look at if you wanted to look at that. The other thing that we're adding, it's on page 10. We're adding a new exception to the Kansas Open Records Act, and that is that records of a public agency that contain material that is obscene, as defined in KSA 21-6402 and amendments thereto, are part of what is exempt. And what's happened here is, you all remember, we passed the age verification bill last year, age verification for the pornography websites. And so that there was some issue of someone sending images to the Attorney General's office to say, I got on this website and I wasn't supposed to. And so see, they're not doing what you're not doing what you're supposed to be doing, and so on. And then someone turned around and asked for those open records in that civil suit, in a civil, I don't know if it was a suit or just information, to be returned to them. Okay, so criminal obscenity and criminal records are not part of the Open Records Act. So we needed to have a little piece saying in the civil area, records of a public agency that contain material that is obscene are also exempted from the Kansas Open Records Act. And the Attorney General's office asked us to do that so they didn't have to provide obscene material when they were requested. And that's how it happened to come up. So are there any questions about that piece in particular? Representative Carmichael.
And I probably will have argument in opposition to the amendment as well, but for now, the questions have been what have been invited. Has there been a hearing anywhere in this legislature on this idea?
Of adding the exception?
Yes.
No, it's an amendment today to this bill.
Whenever you want comment, an argument, if you will, on the amendment, I'd like to make some.
Okay. Very good. Also, another area that was an amendment that seemed to be necessary is on page 14, and it's about live streaming And it's saying that a public body or agency that voluntarily elects to live stream, they have to live stream all aspects of it. And I guess there were some issues where maybe a PowerPoint or whatever wasn't, but we all know that there's technical difficulties, and we have had that happen in the State House also. And so there's an amendment added that says an unintentional technological failure that disrupts the live stream shall not constitute a violation of this subsection. Okay. Well, let's just do it all at once. Okay. And then, what's the next one? That's all those lines? Okay. Okay, so then the other thing I asked for personally was I felt like giving 5 minutes extra. That those lines are in the italics around page 14, line 32. That they can conclude 5 minutes earlier or later than provided in the motion. I just felt like we need to abide by what we say. We're going to come back when we say we're going to come back, and I'm not really. I feel like if we give a 5-minute grace period, then we might need to give a 10-minute grace period. And I feel like if we have a closed session, then we need to be back when we say we're going to be back. That was my personal amendment. And then I think that was it. Is that it? Yep. Okay. So several pieces to this amendment to amend Senate Bill 70. And now I'll open that for questions. Representative Vaughn.
Thank you, Madam Chair. I think this is probably a revisor question, and I'm sorry for missing his brief just now. So this takes out, so my primary concern with the bill was just that we really only had testimony on the first section, we only had one proponent on the first section of the bill and didn't have a proponent or testimony on the remaining sections of the bill. And I think I generally support them. I mean, I support the effort to increase transparency. I was just kind of concerned that we didn't have a hearing on those other sections, but this addresses some of that. So I'm just wondering, outside of the first section around to open records fees in the bill that we originally heard as a House bill, what other new sections remain with this new amendment, if that makes sense?
Madam Chair and Representative. So what would be left is the fee provision, that's section 1, but the House version, which is attached, as the chair mentioned. The second piece is still in this amendment, that is exempting from disclosure formally closed investigations with no found violations. And that's the big section of current law, section 2, that has the 50-some exemptions already. And then Madam Chair mentioned she's adding a new exception to that list about obscenity, obscene material. And then the third piece that's still in here is the reporting of violations by county and district attorneys to the Attorney General. That would still happen in October instead of January. The open meetings piece about membership, calculation of subordinate groups like subcommittees is still in there. The live stream meetings to ensure the public observes all aspects of the meeting, that's still in there, but with an additional amendment that the chair addressed, and that would be it.
Okay, that's helpful. Thank you.
Representative Carmichael.
And so that I'm clear, Madam Chair, are we still on questions and not yet to discussion of the amendment?
No, discussion is fine. Yep.
Oh, great. Okay, well, let's start with the questions. At page 14, the balloon. What does it mean when you say in your amendment or an action taken by the provider of the selected medium?
Jason, would you like to answer that? Yeah.
So, Madam Chair, the request that I was given was focused on what happens if the selected medium that the body is using, that's referred to in line 22, what happens if they do something that is not under the control of the public body? So, for example, WebEx decides to drop service to the legislature during our meeting. That was not a decision of our chair or this body. That was a decision of WebEx, or you're broadcasting on television and the television company decides we're going to switch our programming to something else. That wasn't the body's decision. That was the person providing, or the provider of the medium. Those were the examples I was given. So that's the idea.
By way of discussion, this is very poor selection of words to accomplish the purpose. Selected medium, that doesn't say live stream, that doesn't say broadcast. It says something about a selected medium. And I think it's very vague, very confusing. It's not well defined. And I don't think it's a good idea to just drop this into a statute without the benefit of having held a hearing to discuss the possible consequences, collateral impacts of this addition to the balloon. You want me to proceed to my next? Madam Chair?
I might just answer that. So you're speaking of the balloon, even though the statute that we're hearing, the bill that we're hearing, Section J, uses medium 2 other times. So it's
Maybe it does. I'd ask the reviser to help me out and read this for me, because I haven't had a chance to read the approximately 15 or 10 pages that have just been placed on my desk.
So if it's okay, I'll just, so when we heard the bill that we heard on page 14, subsection J, public body or agency that voluntarily elects to live stream their meeting on television, the internet, or any other medium shall ensure that all aspects of the open meeting are available through the selected medium for the public to observe.
I now see the language, and I'll withdraw my concern.
Thank you.
Would you like to proceed to my next concern?
Does anyone have any questions about this particular balloon piece?
Yes, this is about the balloon. That's what I'm
Okay,
wanting to ask about.
I thought you were going
balloon
to.
amendment.
Yes, I thought you were going to another section. I was asking if anyone had a question on this
Yes,
particular
yes.
section.
The portion of the balloon amendment that I'm concerned about does not appear on page 14.
Okay, anything else on page 14? Okay, yes, please proceed.
As I understand the purpose of the balloon at about page 16, and I must confess that I have not read it, as was obvious from my last question. I think what the intent here is to do away with the 5-minute grace period for returning from executive session, and that grace period is provided for in the original bill that passed the Senate. Am I understanding the purpose correctly? I'd ask that of the carrier of the amendment who brought the amendment.
Yes.
Okay. You know, the 5-minute grace period was a good idea. Anybody and everybody can wait 5 minutes. If you're in executive session and you look up at the clock, you ought to be able to wind it up in 5 minutes. That's not going to hurt anybody. But if we're going to get to this precise start on time, stop on time, I trust that this committee will never be late in starting and will never be late in stopping. I think that the Senate was right in the language that they used in chairing meetings. Sometimes you just don't get back quite as quick. Sometimes people even want to stop and go to the bathroom after executive session before they come back in. And this is just too strict. This is too school teacher, school marmish for me to support. Thank you.
Okay, committee, I just want you to understand that right now there's no, it's just when we go into executive session, we say we'll return at 10:30. And if you've been in a legislative committee where we do that, everybody leaves and the revisers are very diligent to tell us, okay, your time's up, we're coming back in. That's how it works. I find it elementary that we're going to put in our statute that there's a 5-minute grace period. I think we should all do what we say we're supposed to do. And if we need to stop and use the restroom, coming back in or however, getting up and going out, we just do that. That's fine. But I don't think it needs to be in statute that there's a 5-minute grace period. I felt that that was not necessary when we're talking about executive session. So that's why I personally wanted it out. Representative Boheim.
Thank you, Madam Chair. Because I'm new and I don't really fully understand executive session timing and therein. If you need more time in executive session, do you come back and then go back into executive session?
You
Is that
have
how
to
that
come
works?
back. You have to say when you think it's a time stop. You say when you're going to come back into regular session. If you need to go back into executive session, you can go back. You have to make a motion, go back into executive session.
Thank you.
Okay, any other comments? Representative Carmichael.
Well, I heard the comments of our chair as to her reasoning for for striking the 5-minute grace period. And, you know, I'm not going to impugn any representative's intent or motives because I don't know what the intent is now. Is the intent to say it's okay to violate the law and take 5 minutes or 6 minutes or 7 minutes or 20 minutes, the slippery slope that we heard described earlier? Or is this a strict, we're going to set a bell like in school, and when it rings, class is over, or when it rings, you better be in your seat? I do not understand what our chair is attempting to accomplish by taking a reasonable idea from the Senate that would allow a little bit of leeway that is consistent with the common practice in every board and commission that I've ever been on, and just strike it? What are we wasting our time here doing today? Thank you.
Representative Esau.
Thank you, Madam Chair. I won't belabor the point, but I will say about 2.5 years ago, I was on a joint committee that spent most of the day in executive session. I got very good at saying why we were going into it quite quickly. But we came back every time and picked another time that we thought would work. And when we needed a personal break, we maybe recessed instead of going into executive session first. But we came back every time, and it did not delay us that much. And at least the public then knew what we were doing. So I don't care one way or the other if we put grace into the statute or don't put grace into the statute, but it wasn't, it did not slow down the process of what we were doing by enough to care greatly. I just thought I would share that for those who have not experienced it.
Thank you. Yeah, and we don't do executive session all that often, so I appreciate that. I like the statute the way it was. I just want to go back to how it was. I think it has been successful in the executive sessions that I have been involved with. So that was my idea in that. Any other? Representative Barth.
Thank you, Madam Chair. I'm moving on to a different area, if that's fine by you. Okay, page 14. Wait, never mind. Not that page. That's what we just talked about. Page 9 or wait, 10. Page 10. The new balloon on that, where it's going in there at like 31, 32, about the records that may contain material that is obscene. I think it's interesting, this is just kind of more of a comment to the committee that we're saying that we won't provide this obscene material to the public when they're requesting it. Yet we have in Kansas statute today that public schools and public libraries can promote obscenity to minors and children in schools. So I just want to make that comment because I think that's quite ironic that we're doing this, yet we allow schools to promote obscenity. And I just think that's kind of interesting and wrong. And I wonder how this is First Amendment rights related, but that's what I keep hearing on the other things. So I don't really agree with it though, but just had to make that comment. Thanks.
Any other comments on the amendment or questions on the amendment? Either way, discussion? Okay, I will go ahead and, move my amendment to Senate Bill 70, and I have a second from Representative Williams. Any other discussion on the amendment to Senate Bill 70? All those in favor say aye. Opposed, no. Then the Senate Bill 70 is amended according to this amendment here. Representative Carmichael,
May I
on
have
this
my
in
negative
particular? Okay,
Negative vote recorded on the amendment.
yep, you certainly may. Anyone else? Okay, now committee, we have discussion on Senate Bill 70 as amended. Representative Williams.
Thank you, Madam Chair. I move that we pass out Senate Bill 70 as amended favorably for passage.
Representative Lewis seconds. Any discussion on this bill as amended? Representative Carmichael and then Vaughn.
Thank you. I won't take much of the committee's time here, but I will make a prediction that someday we will regret having provided another exemption to the Kansas Open Records Act, one that is based upon materials being quote-unquote obscene. Because what we'll probably find is police departments that won't release dispatch audio, police departments that won't release body cam video and audio, that there will be facts and information that a free and democratic people need to hold their government to account, that government will hide behind their newly granted obscenity exception. I think it's a terrible mistake. Thank you.
Any other discussion? Okay, seeing none, or I'm sorry, Representative Vaughn, yes.
Thank you, Madam Chair. I guess I'm struggling because I'm reading through each of the sections of the bill, and because we didn't have testimony, I don't understand why certain changes are being made. I guess I would maybe open it up to the committee, or if their advisor would have potentially an answer, but mainly my question is around two sections. So when the actual complaints are filed with the Attorney General for core and coma, so this bill changes the date from January 15th to October 15th of each year by which the county or district attorney of each county must report to the AG all core and coma complaints received during the previous fiscal year. Do we know why that change is being made? Is that just so that the reports are more timely? I guess that would be one question. And then the second question is, so the subsection or the section regarding the subordinate groups, it changes the language on page 14 of the bill, but my interpretation of the change is exactly what it was. So it changes it from when a public body or agency subject to the act subdivides itself into subordinate groups, total membership of the subordinate group shall be used to determine if majority membership participated in a meeting. So I read that as subordinate groups are still subject to the majority rule, where if they have a majority, it's subject to core coma. And then it changes that to when subcommittee or subordinate group is created by a public body or agency, whenever majority of such subcommittee or other subordinate group meets, such subcommittee or other subordinate group shall be subject to the requirements of this act. So I guess maybe it's the shall be subject to the requirements of this act. So I'm trying to understand what the change is there. I guess those would be my two primary questions, and since we did not receive any testimony on why those changes were being requested.
If I may, Representative, I had the same question. I can understand why you're asking that. Apparently, there were some public bodies that had subdivided themselves and they felt like they were not required to participate in the Open Meetings Act. And so they just wanted some language that made it very clear. Okay. And it was that because I asked the same question and I was told that this language just clarified, didn't really change the law, but maybe there were some words that made them feel like it was a little squishy. So this was just more clear. Clarified it.
Thank you, Madam.
That's what I was told. Mm-hmm. And I'm sorry, what was your other one?
The date change from January to October.
Representative Williams.
Thank you, Madam Chair. I'm told that the change in date allows for more time to process the larger report that is submitted to the legislature.
Okay, Which that makes sense, so that it's ready for when the legislature meets in January. Okay, I feel more comfortable with it now. Thank you for allowing me to ask those questions.
Committee, any other questions on Senate Bill 70? Representative Carmichael.
Thank you. I think my question might best be for the reviser, and I apologize. I must be slow today. I've already missed one point in this amendment. What is the purpose of the documents that are appended to the balloon? I'm not figuring out how they fit into the statutory language that's contained in the balloon.
Madam Chair and Representative, so this is a case of me trying to be helpful and maybe not succeeding, but the House Bill 2134 attachment, that is the language you put in place of Section 1, so you'd be able to refer to exactly what you passed before. That will be Section 1 instead of what is there now. And then the copy of KSA 21-6401 just has the definition of obscene that's used in that new exception. So in case you wanted to see with your definition, it's provided in that statute, but there's no change made to that statute.
Madam Chair, under the circumstances, I do appreciate the help. I just wanted to make sure I understood that this wasn't something that was being incorporated lock, stock, and barrel. Thank you.
So what I just asked Jason, I would like to just report to them. When anything we have, the Cora exceptions, anything we have amended or added new, there is an automatic review after 5 years. And so that's why, we pass that Cora exception bill every year where we have to look at things. So this one would be included in that would have a review after 5 years, just for your own information. Representative Bohai.
Thank you, Madam Chair. Jason, thank you for putting the 21-6401 on there. I did look it up and to look at how we were defining obscene, and it seems like obscene is referring to essentially sexual obscenity, not profane language. So I can get behind the amendment of not releasing the obscene imagery.
Okay, any other questions or comments on Senate Bill 70? Okay, with that, I close. Yes, I'm sorry, she closes.
Thank you, Madam Chair. I close and move my motion.
Committee, you've heard the motion to pass Senate Bill 70 favorably for passage as amended. All those in favor say aye. Opposed, no. The ayes have it, and we will pass Senate Bill 70 out favorably, and Representative Carmichael would like his no vote recorded.
Thank you.
Anyone else? Okay, can we get to one more? Let's do Senate Bill 128. It has to do with social workers working under an attorney and therefore not being mandated reporters. It was March the 10th. Okay, we'll go ahead and open that up for discussion. Senate Bill 128. Does anyone have any comments or questions on that one? Okay, seeing none. Representative Williams?
Thank you, Madam Chair. I move that we pass out Senate Bill 128 favorably for passage.
Do we have a second? Representative Schreiber seconds. Discussion on Senate Bill 128. Representative Bohai.
Madam Chair, I will not be voting in favor of this bill.
Would you like to explain to the committee why? Or you can keep it private?
No, that's fine. I think that we have mandated reporters for a reason, and the fact that we could have inadvertently more victims that are not able to seek justice because the onus is on the victim, and if they are a minor, that can be hard. I stand in opposition. That being said, I feel like there's already a workaround where non-licensed people with the capacity to hold these interviews are currently going on, and so I'm not certain why we are making an exemption. Thank you.
Okay, any other comments? Representative Lewis.
Yeah, so I appreciate the concern of Representative Bohai on that, but I do think there's a legitimate concern by the proponents about providing defense to people who we may believe their alleged, and I emphasize alleged behavior is abhorrent, but how they need and deserve a good defense, and this is one way that it's helping them. I would also say that we need to expand our mandatory reporting laws to include clergy. Thank you.
Any other comments? Representative Barth.
Thank you, Madam Chair. And I think this is for Revisor Jason. Can you remind us if there's anything that's requiring the attorney or the licensed clinical social worker to notify the person that they're working with that they still have a right to talk to somebody that's outside of them, but that doesn't fall underneath these? I guess I don't, and I know I'm getting a little bit tired too, so I don't know if that makes sense because I'm trying to remember what this bill does exactly. And is there any, does that make sense, or is it even applied to this situation where they would need to let them know that they have rights still to see someone, that but this person can't say anything? Like, what if they've told them something really private that is of concern that really some other adult should know, and that they're keeping it private and they won't let anybody else know it? This child thinks this adult's going to protect me.
Jason's going to give it a shot.
Madam Chair, yeah, I'm not sure I have a good answer. Both the social worker and the attorney would have professional obligations to assess that situation, right? But they also would have the duty to keep that confidential under this bill.
And,
so,
I just might mention, I suppose it could happen that it's a minor who's speaking with the attorney, but in my mind, it was adults that might, I'm happy for others to, it didn't specify, but when it's an attorney working, I just was picturing the person who had been charged with the crime was an adult. Yes, Representative Bohai.
I believe when they're doing the interviews, and part of the reason of bringing the social workers in is to do the more in-depth interviews of the entire system and entire situation, so they could be interviewing minors on behalf of the adults.
As witnesses or
think.
deposition. Representative Vaughn.
Thank you, Madam Chair. That was kind of, at least from what I'm understanding from the question, something I was curious about as well. And that's something that I asked in the hearing in terms of, how will, or how does it apply to ongoing crimes, for example? So the situation I used was, if the person who had been accused of something, if they had knowledge that their spouse, for example, was abusing or neglecting their child, for example, would they still have the obligation to report? And the attorney had indicated that there is, within their profession, they have an ethical obligation to report ongoing crimes under a crimes and fault exception is the term that I have. So I think if there's any knowledge of ongoing crimes that are or could happen, there is an obligation to report that by the attorney and by and therefore by the social worker, even under this law.
past versus ongoing or future. Okay. Any other comments or questions on Senate Bill 128? Yes, I'm so sorry. Gotta wave me down.
It's okay. I just want to make people understand the law and the ethical requirements of people working in the legal field, whether they are a lawyer, whether they're a legal assistant, whether they're the receptionist, whether they're a social worker, etc. If you have knowledge that someone is about to commit a crime, then the rules of confidentiality just don't apply. And if you know that your advice is being used to facilitate the commission of a crime, then you've got to withdraw, and you've got to, if there is an intent to commit a crime and it's genuine, you've got a duty to report that to the authorities, just like anybody else. But when a social worker takes off the social worker hat and works in a legal context, they ought to have to abide by the legal requirements, the law practice requirements of confidentiality. If they work in a therapy setting where they're providing services, then they need to comply with the social work standard. And it's important that people who are social workers be involved in some of these legal jobs because, quite honestly, fortunately, I don't, with one exception, I've never been involved in the situation where I've had to interview, a small child who's been involved in a traumatic incident. But what I'm taught in law school was left me woefully unprepared for that type of work. It is much better, whether they're the victims of crime, the victims of an accident, whatever it is, that someone who has appropriate training work with children in these situations, because I presume they're taught to assess nonverbal cues and a number of other things in doing an interview that aren't my area of expertise. So I think this is good legislation. I think it's a good idea. I don't think it endangers children. I think it actually helps children, because when they are interviewed in difficult circumstances, hopefully the person doing the interview has more education in dealing with these circumstances than certainly I ever received in law school. Thank you.
Representative Bohai.
It's my understanding that this legislation was brought because we are trying to provide more, and I think I'm quoting, holistic defense. They're wanting it so they can go in and do the more in-depth history so that they can then figure out what services the defendants are in need of. And I don't know if the interviews then can help them plea and those sorts of things, but it's when the social workers are interviewing the defendants, it's to help them get the defendant get, as my understanding, a more holistic defense.
Any other? Yep. Thank you. Any other? Is that a hand up? Okay. Any other comments or questions on Senate Bill 128? Okay, seeing none. Committee, you will close on your amendment.
Thank you, Madam Chair. I close and move my motion.
Second.
Didn't I already do that? Yeah.
Okay, great. So committee, you've heard the motion to pass Senate Bill 128 favorably for passage. All those in favor say aye. Opposed, no. The ayes have it, and we have passed Senate Bill 128 favorably out for passage. That's all we're going to do for today.
I'd like to have my affirmative vote recorded on SB 128, please.
Very good. Positive vote. Okay, if you're taking notes, what we're going to work tomorrow, Senate Bill 186, Senate Bill 241, Senate Bill 204, House Bill 2401, and House Bill 2389, plus the two bills that we heard today, we might possibly work, Senate Bill 237 and House Bill 2404. So especially the ones we heard today, there are some amendments with those other ones that are already in place that we didn't get to today. But especially if you have any amendments on 2404 or 237, please get with Jason as soon as possible. And do we have any questions, committee? Anything else? Okay, thank you for your really great work. Appreciate it. We will see you tomorrow. We're adjourned.